Emmy, move on to our first inquiry. And it's not actually a question, but a welcome request, if I may. Could you please talk a little bit, discuss the different opinions expressed by the judges of the UK Supreme Court regarding the assessment of infringement of Swiss form claims, please?
Yeah, absolutely. Yeah, so you're absolutely right to say that, these comments were obiter dicta, so they're persuasive for the lower courts, but they're not, strictly speaking, binding. And also, as you say, in the UK, perhaps it's more likely we will be looking at the new form of claim, EPC 2000, so it's not exactly clear also how these comments on the Swiss form claims, what impact they might have for the new form of claim. But and you're right to say that the judges had different views, but only in respect of direct infringement. So the Supreme Court was asked to consider infringement on two different bases, indirect infringement and direct infringement. So the direct infringement here was dealing with the product of the process, using the compound in the manufacture for the purpose, while the indirect allegation of infringement was supplying this essential means in order to put the invention into effect. And there's a question about how that should be interpreted. So I guess, first of all, maybe I can ask a question back, because in the UK, the one thing the judges did agree on was that there was no indirect infringement. So they did reject the allegation of indirect infringement, and they were all decided on that. Whereas I think maybe that's perhaps out of step with other countries in Europe, where it looks like the courts might consider an allegation of indirect infringement. So do you think in Brazil, this is going to end up being particularly one or the other? Do you think that people will be arguing it in both ways, indirect and direct infringement?
You are talking about direct infringement from the generic company, right?
Well, so I guess in the case of the direct infringement, it would implicate anybody who deals with the product of the process. So if the process is infringing and then the product of the process, that could implicate people who deal with the product downstream in a commercial sense, so wholesalers or distributors. And if it's indirect infringement, then we're looking for a direct infringement that could, whether that could be a pharmacist dispensing the product with the label on it to say it's to be used for a particular indication, and then supplying the drug to be used in that way could be seen as being an indirect infringement. So yeah, I think it's kind of it's all very much open to argument, and I don't know where things have got to in Brazil. Is it being argued in both ways?
Okay, I mean, in that specific case that I talk about it, the only direct infringement, there is no indirect infringement, right? And I struggle, even though first let's start. In Brazil, Swiss type use claim, right? So we are talking in a use claim is a process claim.
Yeah.
So according to our law, a process claim also covers the product directly obtained by this process.
Yeah.
Okay, that's for so in theory, at least the pharmacy, the doctor could be infringing this second medical use if they are prescribing for this. But I really struggle to see indirectly or directly infringe this second use medical patent, especially because in Brazil, our law established that therapeutic method is not patentable. And basically, when the doctor is prescribing, they are doing a therapeutic method here. They are prescribing the medicine, right? So talking about indirect infringement from a generic company, I don't see, because if there is no direct infringement from the pharmacy on the doctor, cannot exist an indirect infringement from the generics. But I do believe, and that's what we are discussing here in Brazil. I don't know if this case or other case will reach the higher courts, but so far, only direct infringement. Basically, I'm now copying the judge's rationale in the decision. As long as the generic manufactures a medicine that can be used for the patent therapeutic indication covered by the second medical use, then there is infringe, direct infringe.
Yeah, I mean, I think that that's something that was really on the minds of the judges in the UK as well, is that this problem of creating infringement for the parties kind of downstream of the manufacturer, so the pharmacists or the doctors, when obviously there is this exclusion for methods of medical treatment. And I think that was, an important policy concern. But I think for indirect infringement, the UK judges of the Supreme Court just felt that since the process covered the manufacture, then that infringement couldn't be completed by the downstream parties because they weren't carrying out any act of manufacture. And that's why the kind of court just ruled out the indirect infringement. But speaking about the direct infringement, and that's where you're absolutely right, the judges did take different views in relation to the direct infringement. And they were being asked to consider the kind of mental element. So at the hearing, the parties, both the generic companies and the patentee, were agreed that there needed to be some kind of mental element, some kind of perhaps intentional. It was argued about what word was being used. And then the generic company took the view that that kind of intention needed to be a subjective intention. So the patentee needed to be able to prove that the generic company had a specific intention that the product should be used in this way. Whereas the patentee took the view more aligned with what you've described, Bernardo, that even if it's only foreseeable that the product could be used in this way, then a reasonable company should be taken to intend the consequences of its actions if you can see that those consequences are going to follow. So in that case, just it being foreseeable would be enough for the product to be for the purpose, for the patented indication. And that was during the hearing. And then the judges were obviously not sure about only those two options. And they asked the parties to address them further about a third option, which is kind of referred to as the outward packaging analysis or approach. And it's often kind of considered to be aligned with the German law style approach, which is really looking at the product and then focusing more on the characteristics of the product, which basically in the case of a pharmaceutical the label is a very important part of that, because the product itself, it is identical. And so after the judges had been asked to be addressed about that question after the hearing, in fact, two of them took the view that that would be the way to assess infringement. So look at the product itself and assess whether, based on its outward characteristics, particularly the label, it's been prepared for the patented indication. So that was Lord Sumption and Lord Reed. Meanwhile, Lord Briggs and Lord Hodge did think that there should be subjective intention on the behalf of the generic company. So you actually have to prove that they'd intended, whether you could find that through disclosure or through other means, for example, the fact that they had projected in their internal planning that they were going to sell some certain amount. But that was not a straightforward thing to prove, and the judges were worried about that. How can you produce that evidence? And then the fifth judge took a view that wasn't clear whether it was completely aligned with the other two groups, and probably more aligned with the outward packaging approach, and saying really the question is whether the generic company has made it clear that the use of the product should be limited. And that judge sort of talked about, could there be some kind of labeling on the product that says this product should not be used for the patented indication? And there's a question about from country to country whether that kind of thing is permissible. So really, I think it's easier to say what the judges agreed about in terms of what they rejected. So they rejected that kind of foreseeable standard that the Court of Appeal had settled on, and that you've also, sounds like that's also where the Brazilian courts are heading. But the Supreme Court didn't endorse that approach. And they were I think that was a concern about whether other parties dealing with the product would be able to know whether it was infringing or not, because how can those parties know what was intended or what was in the what knowledge the manufacturer had when the product, as far as they can see it, just looks like it has the skinny label. They don't know. So, I mean, in Brazil so far, are those the kind of arguments that have been put forward? It sounds like the foreseeable test is something that the judges have grappled with.
How about you, Amy? Do you agree with me? Is a skinny label a foolproof method to rule out infringement of second medical use, or there are limitations for this practice?
Yeah. Well, I think absolutely that's it, Bernardo, isn't it? That's kind of the crux of the question is, are those two questions the same thing? Is it enough to have a skinny label to rule out infringement? And is it enough to have a skinny label to rule out use for the patented indication? Because, if you can't rule out use for the patented indication, does that automatically mean that you must therefore be infringing? And where should that burden, that responsibility perhaps lie? I mean, and I think you can see that the generic companies, they do stand to benefit financially from all the sales, regardless of the indication. And so it's both a combination of the system, the way the system works, which you have to look at in each country, and the kind of scenario you described, but also look at the party that's doing the commercial acts and benefits commercially, even if the use is for the patented indication. But I think a very similar situation to what you're describing kind of arose in one of the cases in the Netherlands that the Court of Appeal talked about, which was a similar case where the generic company had a skinny label, participated in a tender that would supply the entirety of all indications, and then wrote a letter after winning the tender to say, as a formality, oh, by the way, our label is only for one of the indications. And the court in the Netherlands said, no, that is infringement, because just writing a letter after you've already been awarded the tender, sort of as a formality, is not doing enough. So how much do you have to do? And I think you really have to look at the specifics of each system and how it works, because in the UK, where prescriptions are written using the INN, it's not possible to know what the indication was. So when the pharmacist then receives the prescription, they've got no way of knowing whether they should dispense the branded originator drug because it's for the patented indication, or whether they should it's fine to supply the generic product. And so, basically, if the system doesn't allow that differentiation, or the tenders don't differentiate between what the indications are, then it's basically going to be almost inevitable that this kind of off-label use will occur. And then the question is, if it's inevitable, does that mean it's kind of too difficult for the generics to do something, or does it, it's kind of out of their hands, it's just built into the system, or does it mean they should still try and do something about it? And I think there are some other examples, so one company in the UK case, because obviously there were multiple generics, one of them said what it would do is store the product in its warehouse and then only supply it to a pharmacist if the pharmacist provided a copy of the prescription that showed that the prescription had been written for the patented indication. And actually, I believe the patentee, so Pfizer, Warner Lambert, agreed to that process to say, okay, in that situation, I can see that your supply would not infringe because you've seen some kind of evidence that this supply you're making is not going to be used for the patented indication. But of course, the other generic said, well, that's just not going to be practical. Yeah. How are we going to make any significant level of sales? Then it would make our product commercially less desirable. And also pharmacists might be discouraged, but there might be problems about sharing the prescription. It might make things too slow. So it's kind of, I think you can think of things that can be done that would definitely significantly reduce the probability of the cross-label use. Yeah. And I think you've got to be a bit practical in that circumstance. And patentees probably have to be a bit reasonable as well and say, maybe we can't eliminate every single, but we can get it down to a de minimis amount if you take these certain steps. you know, and in the UK, there's quite a lot of scope for the parties to have that kind of correspondence and discuss these ideas. I don't know whether that's possible in Brazil as well, for, you know, maybe for the parties to ask the court to order certain practical steps to be taken, rather than just issuing an order that says, don't infringe the patent, but doesn't give anyone any actual practical advice about how to make sure they don't infringe the patent.